Hello everyone, welcome back to our channel. This is MAHEK, a legal internet LEXIS and company. Today's topic of discussion is doctrine or separation of powers. Separation of powers clear. Separation of powers clear, as the term indicates. It means separation of responsibilities of duties among various organs of a government. What these organs or what these organs are. A government have three basic sections. First is the legislature. Second is the executive, and third is the judiciary. Work of the executive is to prepare the draft of the laws or to enact these. The work of the legislature is to draft these laws and to pass these laws or to enact these laws. Executive's work is to enact these laws at the lower levels and further to check the authenticity of these laws. Further, the law of judiciary is the law enacted by the legislatures are being followed by the public at large, and they are constitutionally valid, or they are not being are they being obeyed by the by other. So this or separation of law, as we know, is not the similar from the very beginning. Earlier, it was first time the term, or you can say traces of this doctrine first was arises from the book of Aristotle, who in his book defined three branches of government, that is deliberative, ministerial, and judicial. Later in 17th century, John Locke talked about the discontinuous legislative power, continuous legislative power, and federative power. Further, in Montesquieu, who for the first time specifically gave this term separation of powers in his book Spirit of Laws. He say, according to him, if an organ is empowered with all the powers, or if all the powers is accumulated in one hand, there can be no liberty for others. There would be a state of arbitrariness, and that power could be misused by that person. So he proposed this model. According to him, he divided the power as general legislative power and the executive power. Later, this executive was further classified under civil law. It was this executives were to perform this executive function as well as judicial function, but on the other side, these executives were also to perform the Locke's federative power. What was it? That was the power of conducting foreign affairs. So then we come one of the traces that exist as present. What are these? These are the threefold structural classification as given by Varde and Phillips. According to him, same person should not form part of more than one of the three organs of government. One organ of the government should not interfere with any other organ of the government. One organ of the government should not exercise the functions assigned to any other organ. We'll see that in India we do not follow this typical, or we cannot say this contemporary doctrine of separation of power. We have a blended mode. We do have separation of powers of different organs, but we do not follow it in a strict sense. What the purpose of this doctrine was is simple: is to avoid the arbitrariness in the nation, is to avoid the rule of dictatorship by preventing the accumulation of power in one hand. Now let's start with separation of power in India. As I have already said, India do not follow the doctrine of separation of power in a strict sense. It do follow, but in a blended manner. India have a parliamentary form of government, so the three organs are well mannered, established, and are well mannered, separated from each other, but they work on a principle of check and balance. if one function does if a function creates mischief, or the one function behave in an arbitrary manner, then the other function could prevent it from doing so by the check and balance principle. For example, Article 53 of India says the president is the executive head of the nation. However, he is only a nominal head, and we all know the real executive lies in the head of the Council of Ministers, by whom decisions the president is bounded. Then Article 123, President is said to be executive head, but still he has legislative authority under Article 123 by way of ordinance making. Then Article 50 talks about separation of judiciary, but the judges of the courts are appointed by the president himself. Even the Supreme Court can perform legislative powers when the question arises to when the question is of fundamental rights of the nation, or when something unconstitutional is happened. He can even declare the act of the legislature as unconstitutional by taking suo motu cognizance. In that way, he hold the power of a sort of legislative powers. So clearly, India to form a functional overlapping, working on a principle of check and balance, but it also follow the doctrine of separation of powers. The sole purpose was to maintain harmony among all the three nations and to avoid accumulation of powers in one hand. That is what India has intended by this adopting this way of working of his administrations. This was all about the doctrine of separation of powers with respect to India. Hope you like this video. Do like and share the channel. Thank you.